As noted in my remarks last night, our goal in each of these panels is to present you with a diverse set of views, and I think we saw a good example of that at the beginning panel, in which we can go in depth on many of these things, but see different perspectives and from different areas of practice. And we are continuing that with a second panel, whereas we were focused largely on litigation developments in the first panel, we will look at legislative developments in this panel. Delighted, honored, and pleased to have Justice Sabrina McKenna as our moderator for this panel. Justice McKenna has been on the Hawaii bench since 1993. She was appointed to the Hawaii Supreme Court in 2011. She graduated from the University of Hawaii at Manoa. She also graduated from the William S. Richardson School of Law at the University of Hawaii. She practiced civil litigation and business law, as well as was in a general counsel's office before joining the bench. She also has taught as an instructor at the University of Hawaii, as well at the School of Business, as well as an assistant professor at the William Richardson School of Law. And she is also a member of our advisory board for the Law and Economics Center's Judicial Education Program, and we value her advice and her regular participation and leadership in the LEC. With that, I turn it over to Justice McKenna to lead us through to our second panel. Thank you.
Thank you. And good morning and aloha, everyone. I have my colleague, Todd Eddins from the Hawaii Supreme Court, is also here. It's truly an honor to be able to moderate this panel with these two very distinguished and knowledgeable attorneys. To my immediate right is Nate Finch. He is a partner at Motley Rice, and he is on the plaintiff's side. Let me just say he has more than 30 years of experience, including asbestos and tobacco litigation. I'm not going to get into all of his credentials, just a wonderful background. Please take a look, and you can get to know him better. But I'd like to mention one fun fact. He attended college and the first year of law school as a varsity track athlete, so on scholarship, so that's great. That's wonderful. And to his right is Mark Behrens, and he is co-chair of the Public Policy Group let's see, oh my gosh, I'm totally missing. Shook Hardy. Oh my God, I'm so sorry, Shook Hardy. And he is on the defense side, over 30 years of experience, especially in product liability litigation. And he's a frequent, both of these gentlemen are frequent speakers at our LEC programs. And a fun fact about Mark is that although both are based in DC, from COVID, Mark now lives in Naples, Florida. So he's been commuting all around the country for all of the wonderful work that he does. So what we're going to do is, the last session was focused more on litigation, but of course we did cover some legislative issues in civil justice. This session is going to start with a real focus on legislative developments in civil justice. And I'm going to start with Mark. Mark, if you could start us off, please.
Justice, thank you so much. It's good to see you again. I always admire your dedication to come here from Hawaii. It would be easier to get us to all go to Hawaii, I think, for a program, but it's always great. And I think this is maybe 3 years in a row that we've done this panel on different topics, and it's always wonderful to be with Nate as well. Especially in this setting, I've been deposed by him before, and this is much more comfortable. And fun fact about the other fact about Florida is we moved during COVID because I've got really little kids. I got married late in life, and we had to get them into in-person school. And the fun fact really is not that I went to Naples. It's that I should not have picked Naples, because after 2 years, I wanted to move back to DC, and my wife and kids refused to come back. So I think if I had moved to the middle of nowhere or something, it might have been an easier sell, but I wasn't going to get them back. So with my time today, I'm going to talk a little bit about high-level changes that I see going on in the civil justice environment, and primarily in the states. I'm going to talk about some plaintiff-oriented reforms that we've seen a lot of in recent years, a few defense-oriented reforms, some things that I and then others that I would consider sort of neutral, and to give you an understanding of what's going on and what's changing the environment, because it's changed from my perspective. I represent both the U.S. Chamber Institute for Legal Reform and the American Tort Reform Association, mostly in state-based legal reform, so you kind of understand where I'm coming from on this. I've been doing it for 30 years or so, and at a high-level change, we've seen in the last 5 years really a dramatic change in focus by the plaintiffs' bar. I've been doing this, like I said, for 30 years. For 25 years of that, I would say the plaintiffs' bar was singularly focused on stopping any kind of federal tort reform. And, you know, in that time period, there was really substantial reform passed in most states. As you know, most states now have eliminated joint and several liability. Most states have, you know, innocent seller type laws. Most states have statutes of repose of some sort. Most states have some sort of limitations on punitive damages. So while a lot of activity was happening, frankly, the business focus had been on the states for the last 30 years. For the most part, the trial bar was really focused in Washington, where nothing was happening anyway. And it's always dangerous when you hazard to try to guess what's in your opponent's minds, but I think sometime in the last 5 years, the light bulb finally went off over at AAJ that they've been focused in the wrong place for the last 25 years. And so we're seeing a pivot to the states that we've never seen before. And the other thing that we're seeing that's new is the trial bar, really for my entire career, was focused on playing defense. It was stop the business community from passing civil justice reforms. But what we've seen in the last few years is they've gone on the offensive with really dramatic results, I think, in some, primarily in progressive states. So that's one thing that we're seeing is a change in focus away from Washington, which makes sense because nothing's happening in Washington. They can't pass anything on any issue, let alone legal reform. So you don't see a lot of, you know, so the focus has moved to the states where really it belongs. Most tort law is state-based, as you know anyway. And we're seeing a lot more activity, aggressive activity, pro-plaintiff activity in terms of laws. The other thing that's changed in the last, really not even 5 years, I would say 3 years, is really a dramatic change on the Republican side in who's being elected and where they come down on these types of issues. You know, we are seeing in many states a couple of dynamics. One, I'd call it the real strong emergence of the Republican trial lawyer. You know, these are Republicans that probably vote Republican on every conservative issue, every social issue, and on most business issues, but on tort, they vote with the trial bar. You know, they've gotten very substantial funding from the trial lawyers, and so we've seen this emergence of the Republican trial lawyer in a lot of states that makes it more difficult for me and my clients to try to pass reforms on our side. And the other thing that we're seeing is a new populist element, a very strong populist element on the Republican side. You know, I'll call it the MAGA Republican without trying to offend anybody, but at least when I say MAGA Republican, people kind of understand, you know, where those folks are coming from. But they are as populist, anti-corporate as folks on the far left. You know, there is a sentiment out there. I see James Burnham, we did a program on the Federalist Society a few days ago on why aren't more conservatives in the plaintiffs' bar. And the kind of focus there was, you know, why are Republicans not going more into doing plaintiffs' work? Because there are more and more Republican attorneys general, more and more Republican senators that are philosophically lined on tort with the plaintiffs' bar and not with business. So what I see is, you know, increasingly the number of people that we call allies in state legislatures is getting smaller and smaller. You know, we've never been able to really count. When I first started, you could count on a number of what I would call Main Street Democrats that supported legal reform. Either those folks have been primaried out or replaced by Republicans, so your traditional pro-business Democrat doesn't exist now in most states. So it's very difficult to get any Democrat support on legal reform. And on the Republican side, where we used to be able in the business community count on sort of a unified Republican caucus, we can't anymore in most states. That's fractured, either because of trial lawyer Republicans that have been elected to office or because of populist anti-corporate sentiment with many Republicans. And so we have fewer and fewer friends in the room, and I think that is also providing opportunities for the plaintiffs' bar to go on the offensive. And the last thing that I'd say has really changed in the last few years, last 5 years, and is probably tied a little bit to third-party funding that'll be on another panel, but the amount of money coming into the plaintiffs' bar in the last few years is really unprecedented. If you add in the billions that they're making off Roundup, billions on asbestos, billions on earplugs, that will be multi-billions on Camp Lejeune cases, if you put all of those together, the trial bar would probably be a Fortune 100 company. Seriously. There's $1 billion is spent every year on television advertising for legal services. If you took the plaintiffs' bar and put it together, they would be a Fortune 100 company, maybe a Fortune 50 company. The difference is their sole focus is to figure out how to expand liability and bring more lawsuits. And there's social utility to that, but whereas our clients are spending their money trying to develop new drugs or better cars or whatever, their side is focused just on expanding liability. And so I see us at a big disadvantage. Now, Nate would probably say, oh, we're still David fighting Goliath. From our perspective, the script has flipped. It really has, and we're starting to see that in some of the changes occurring at the state. So let me quickly go through and highlight some of the things that we're seeing on the plaintiff side, and then Nate can respond why this is happening. The first changes that we saw at the state level of plaintiffs going on the offensive were in the childhood sexual abuse cases. Now, that's low-hanging fruit, because who's going to stand up and support limiting lawsuits for childhood sex abuse? The American Tort Reform Association does, only because what those laws have done is retroactively abolish the statute of limitations. So if you were a person whose claim would have expired in the 1950s, now in these states, you can come forward and file your lawsuit. So ATRAS has opposed those simply based on precedent, that, yeah, they're terrible cases, but so is somebody dying of mesothelioma. So is somebody that is a quadriplegic from a car accident. If you start making value judgments that some type of injury is so bad we're going to throw the law out the window, then where does that stop? But we saw a lot of states that did that. And we've seen some expansion there. What started as retroactively abolishing statute's limitation for childhood sexual abuse has now moved into sexual assault in adulthood, allowing those claims to come forward. So, we're seeing that migration. I think the person, E. Jean Carroll, who sued Donald Trump over the incident that happened at Bergdorf Goodman, took advantage of a New York law that did that, for example. So we're seeing that. The other thing that we're seeing really take off is wrongful death lawsuit liability changes on the plaintiff side. In the last year, 11 states have introduced bills, 5 of them passed, to expand wrongful death statutes. We're seeing these laws broaden the categories of people who can sue, expand the types of damages that are recoverable for emotional harm, raise or eliminate caps that exist in the states, and allow for punitive damages. So, for example, Maine this year has a cap on wrongful death emotional harm that had been $750,000, and it was raised to $1 million with adjustments for inflation. Delaware and Illinois both passed laws to allow punitive damages in wrongful death cases. That's a concern to the asbestos defendant crowd, because roughly 1/3 of all asbestos mesothelioma lawsuits in the United States are filed in Madison County, Illinois. So, we look at that as that was really a bill to raise asbestos values nationwide because of that law passed in Illinois. New York has a bill sitting on the governor's desk, the Grieving Families Act, that would do all of these things I talked about: expand the statute of limitations, expand recoverable damages, expand the categories of people that could be sued. In fact, the New York law goes so far that the progressive governor vetoed this bill when it came up last year, because she was afraid it was going to wreck the medical system, the cost system of medical care in New York. But the legislature put the same bill back on her desk, and so we'll see what she does this year. But we're seeing that. And the other thing is either raising or eliminating traditional caps that have been around on damages. Last year, for example, if we have folks here from California, California's micro law was always seen as sort of the national model for medical liability reform. It had a cap that hadn't changed in many, many years. That was raised last year. This year, Nevada raised its cap from $350,000 to $750,000 over 5 years with escalators for inflation going forward. So these are just 3 ways that we're starting to see the plaintiffs' bar go on offensive with really great success. On the defense side, there were 2 states this year that passed really expansive tort packages. Montana, which is a new state that had just become Republican after many, many decades, probably of Democratic control of the governor's office. And Montana hadn't done a lot of things that other states had done over the years, and they were sort of playing catch-up this year. And then in Florida, there was really dramatic change this year because of Governor DeSantis' leadership, and it was really driven by what I see firsthand, if we have any Floridians, the insurance crisis that's occurring in the state. I mean, to give you a perspective of what's happening in insurance, in the 3 years that we've been there, my deductible went from $12,000 with a $50,000 deductible to $15,000 with a $70,000 deductible to this year, $25,000 with a $75,000 deductible.
For which kind of insurance?
This is just homeowners, a wind policy, doesn't cover flood. That went from $2,500 to $5,000. So what I've seen in my personal insurance is that it's gone from $15,000 to roughly $30,000 in the last 2 years. That's in part because of major wind events, but it also has a lot to do with the lawsuit culture in Florida and the laws that made it very easy to bring claims to force insurers to replace entire roofs and things like that. I've seen the scam firsthand because I had a guy come to my roof and tell me that, not knowing what I do for a living, a roofer came and told me how I could scam the system and get an entire new roof that would be worth $150,000. And I called a reputable local roofer who replaced about 30 tiles for $3,000 after the last hurricane. So I've seen how it works, and the legislature is trying to respond to that. Because if they don't, we're not going to see continued economic growth in Florida. I mean, it's just that. Most people can't afford $30,000 a year in insurance payments, especially older folks that are on fixed incomes. So they've got to get control of insurance costs in Florida, and dealing with tort is a big component of that. So, but that's kind of a specialized situation we've got, and that's what I think explains what happened in Florida. Those are the only 2 states this year that passed really sweeping lawsuit reform on the defense side, and I don't think there were any states last year that passed sweeping reforms on the defense side, which shows you really how much the momentum has shifted. The reforms that are being discussed on the defense side tend to be rifle shot bills. So, for example, I've worked on something we call asbestos overnaming. In some states, like in West Virginia, it's not unusual to see 380 defendants named in an asbestos lawsuit. 380 defendants. I mean, it's crazy. And more than 60% of those will ultimately be dismissed without any payment whatsoever to the plaintiff. I mean, we're just seeing this rampant naming of defendants in litigation. Motley Rice is not in this, but there are other firms that are doing it that just, have, it's like you get a complaint in an asbestos case and it looks like the yellow pages. And then most of those companies are dismissed without payment. I don't understand why it's going on. These aren't even nuisance value cases. They're just getting brought in and then let out. But it costs insurers a ton of money to hire a lawyer to defend a case, go to a deposition, respond to discovery, and then ultimately, a year down the road, figure out that you never belonged in the case to begin with. And you get dismissed, but the company's had to pay, let's say, $20,000 in lawyer fees. If you're an insurer and you have 10 defendants alone in that case, you've just wasted $100,000 on policyholders that never should have been sued in the first place. And we're trying to deal with that through some legislation that would require some minimal amount of due diligence before a lawsuit is filed, the types of things that typically happen in other torts. Commercial trucking cases, we're seeing legislation to deal with that. That's an area where tort liability has really taken off in the last few years, particularly in places like Texas that dealt with that this year. And then third-party litigation funding disclosure, I won't go into that because I know you've got another panel. Trip Haston and Aviva Ween from J&J are going to talk about that with James and a few others. So those are the things that we're seeing on the defense side. The last two things that I would say that are have been very active, data privacy. There were a dozen states in the last year or two that have passed data privacy laws. Those tend to provide for enforcement by the state attorney general with a cure period. So it's not about private rights of action for the most part, but I just throw it out there because if we're talking about state legislation, there was probably more state legislation passed on that issue than anything else this year that I follow. And then on jury pay, this is something that we can all get behind, is that, for decades, jury pay has been just abysmal. In some states, the National Center for State Courts found out, for example, that 14 states had not adjusted their per diem since 2000. 3 states had not provided an increase since the 1970s, and 1 state had not done so since 1957. That's according to a report by the National Center for State Courts. Philadelphia for juries, for example, got $9 for each of their first 3 days of service, then $25 thereafter. The initial $9 rate was set in 1959 when the minimum wage was $1 per hour. So, how does this impact? We're seeing that people, the number of jurors that show up and ask for financial hardship excuses is enormous. And I think that's bad for the civil justice system across the whole. Our system works better when there's more diversity, when there's more balance in the jury room. Now, on the defense side, we support this, and I'll tell you a funny side. One time, my senior partner is a guy named Victor Schwartz. Years ago, Victor was supporting jury service reform to make it more easy for people to serve. And they interviewed, I think it was Joanne Doroshow on the plaintiff side, and she said, I don't know what they're up to, but if he supports it, there must be something bad about it. And, in all candor, maybe a case could be made that if you have more diversity in the jury room, you have less swings. There are studies that say that a more diverse jury will listen better, that they may be less susceptible to groupthink, that that they may not jump to conclusions. You have other people that bring different life experiences to the jury. And maybe that translates into, more predictability. I don't know. There hasn't been any empirical evidence that says that. So I don't support these things because I think it's great for pro-business. It's just a great thing for our democracy to allow more people to serve, because I do think, we have seen a loss of confidence in the judiciary. I think most of it is focused on the Supreme Court right now because of some things, the confirmation process, in other words, but it trickles down to you all. And I think from my own perspective that the more opportunities that ordinary citizens have to serve and see the process firsthand and see how legitimate and great our court system is, the more that they will have confidence in that system. So I think that these are really good ideas that states are doing, and we've seen, again, 6 states this year pass really substantial jury increases, some of them doubling jury pay, which they had not done before, and hopefully that will continue. In a couple of these states, it happened, Arizona and North Dakota, I think, because the state Supreme Court wrote the legislature and said, please do this. So maybe this is something you can take home to your own states and your own courts, is better pay for juries. And I know you can't pass the appropriations bills, but you can ask the legislatures to do it, and I'd recommend you think about that when you go home. And that's it for my part.
All right. Nate, your response and any additional legislative enactments that you want to focus on.
Sure. Thank you, Justice McKenna, and thank you to the George Mason Law School Law and Economics Center. This is probably the, 13th or 14th year that I don't always do it every year, but Henry Butler asked me to do it a long time ago, and I appreciate every chance I have to talk. unlike Mark, I am not involved in crafting state-level legislation or even commenting on it very much. I'm a trial lawyer. I spend most of my time doing asbestos cases and cigarette cases. I have a very different perspective from Mark on whether the defense side is spending more time advocating legislation that, in my view, closes the courthouse door. I'm going to talk about what my partners have seen, my colleagues have seen, the various, not just in asbestos, but across the board. One thing I do actually agree with Mark on is the jury pay. I definitely believe that the more people that can sit on juries, the better. I have had the experience many times of seeing jurors who I think would be great for my case or great for any kind of case, and they just say, hey, I'm a plasterer, or hey, I'm a carpenter. I can't sit for 2 weeks on a jury because I take bread out of my kid's mouth, and that's a loss to the civil justice system. So to the extent that you have any influence on your state legislatures or recommendations to increase jury pay, I think that is a good thing. I guess I'll start with close to where Mark ended. The limits on asbestos litigation, the so-called overnaming problem, which I don't, I think it's overblown in one sense. So let me ask a question. Since I often do a lot of voir dire, how many people in this room have ever served on a Navy ship or worked in an industrial facility like a powerhouse or a power plant or oil refinery? 1, 2, 3, 4 out of what, 80, 90 people? So a lot of times in an asbestos case, it's literally a race against the clock and a race against death. Meaning a client comes to you, they're very, very sick. The attorney may know from past litigation because somebody worked at the Norfolk Naval Shipyard or the Newport News Shipyard or in the Bethlehem Steel Plant in Baltimore that there were 500 different companies' asbestos-containing products in and around there. But the client doesn't know that. The client may or may not know, even particularly in the cases that we're seeing more and more of, where people working in the 70s and 80s and 90s. It wasn't like all of a sudden in 1972 when OSHA passed that asbestos just disappeared from the environment. The closest analogy I can think of for judges is imagine if you walked into your office and half the things in there might have been made with something that has an invisible poison, and you walk into the cafeteria and half the things in there might have been an invisible poison, and you walk into a conference room like this, and half the things in there are made with an additional poison. You don't necessarily know when you start a lawsuit. The client doesn't know, and a lot of times proving up a case involves finding coworkers and trying to find coworkers from people who were working 50 years ago, 60 years ago. The client may be dead. You may have a widow that knows her husband worked at the Norfolk Naval Shipyard, but who the people are. So, the sort of limits on asbestos litigation is definitely a defense side bill that has, gotten traction. I think it is seeking out a problem that doesn't really exist. I believe very strongly that people do their due diligence before they file a case, but you shouldn't have to have trial-ready evidence when you walk in the door when you file an asbestos case any more than any other kind of case. And so there is an element of you're trying to make the pleading requirements so stringent that you can't even start the case before you get out the box. Another area that we have seen a fair number of proposed legislation or talking about legislation is state levels of to place limits on public interest litigation by cities and counties. And I think the opioid litigation in part is a driver of this. The concept of public nuisance or the ability to hold someone accountable if something that they create goes off and hurts a large number of people or even any number of people, it really goes back to the Bible. In Exodus, they talk about if your ox gets off your land and goes off and you know that the ox is dangerous and it goes off and hurts someone, you, the owner of the ox, is mean, back then, it was, the owner got stoned, but that you were responsible for that. And so what has happened is that there are now public nuisance lawsuits. I mean, the opioids litigation was a very a classic example of that. The tobacco litigation 25 years ago that my firm was involved in, some of the legal theories involved public nuisance, was brought on behalf of states. And more recently, it's been brought off not on behalf of just states, but also on behalf of cities and counties, because sometimes states have a different interest than cities and counties, or counties and cities are more sort of on the line. And I think there was also a sort of a pushback in the federal, I mean, in the tobacco litigation, the state AG tobacco litigation many years ago. There was a lot of reforms for how the cigarette industry operated, but also a lot of money. And I think a lot of municipalities and cities saw states take that money instead of using it to defray healthcare costs or to spend money on anti-cigarette advertising. It just went into the general budget. And so there was an effort by a lot of cities and counties in the opioid litigation to bring cases directly so that they had more control over the outcome of, what happened. And so what we have seen is that some states, primarily at the instigation of the defense side of these kind of cases, and public nuisance litigation has expanded now beyond opioids. It's into all kinds of pollution litigation and other stuff. And there's been attempts to limit what states or cities can do, whether they can hire counsel, whether they're state or city, like, the state of or a city in North Carolina may not be able to bring a case. The state of Ohio has proposed legislation that would limit what an individual city or an individual county could do if the state AG doesn't control that litigation. Another area that where we have seen, and Mark alluded to this, talked about this, is limits on trucking accountability by the trucking industry. I think most people who drive on the highways in the United States have a real, how many have ever had a close call with a big semi truck? A lot more people that have worked in a shipyard. So juries naturally don't like the trucking industry because the trucking industry has cut a lot of corners over the years, whether it's making drivers work 18 hours a day to make their runs on time, to hiring people that shouldn't be drivers to begin with because of past drunk driving convictions or past convictions for reckless driving or whatever. What we have seen is attempts to limit the liability of the trucking industry. One is the damages cap, arbitrary having a damage cap of $5 million on non-economic damages. Why should that, why should there be a damage cap for the trucking industry and not for, the asbestos industry or the cigarette industry? Another attempt that was, this is actually passed in Texas, something called the McAfee rule, which is that if the trucking company admits that it is vicariously liable for the driver, then other causes of action can't be brought, meaning you can't sue the trucking company for negligent hiring and negligent retention. And a lot of times, some of the worst conduct is in the hiring and training and oversight process. Yeah, it's, they may concede liability that this driver of an Amazon truck it's the responsibility of Amazon. They don't always concede that. But there have been, attempts to limit liability based on, well, if they admit to the fact that the driver is their responsibility, you can't prove the other acts of negligence that they had. I'm going to briefly talk about litigation finance. I know there is a lot of discussion about this. My only point on this is that some of the proposals for disclosure of who's in the financing, who's financing litigation are overly broad and could, in theory, pick up, if the plaintiff lawyer has a mortgage on his house, or if the plaintiff lawyer has pays his staff through the proceeds of contingent fee litigation. I mean, there's always been litigation financing in this country as long as contingent fees have been permitted, in the sense that, generally speaking, my clients never get paid unless we recover money. So there is, and generally speaking, our cases are done on a contingent fee model. So that's always, been perceived to be okay. What I think has been the concern is that when outside parties are putting money into the system, that somehow that is a problem. Why is it a problem if advertising agencies help spend money to go out and advertise for people to protect their rights? Why is it a problem that hedge funds in New York are willing to loan money to lawyers who are on the plaintiff side of litigation? I mean, I think the statistics show that a lot of litigation financing is in patent litigation or business-on-business litigation, meaning that the companies will get financing to pursue litigation that they may not want to spend their capital on, but they'll find a hedge fund that's willing to do it because it's a plausible case. So this is an area where we've seen a lot of activity. I'm not going to get into much more detail than that. Another area that we've seen is, on the defense side, is trying to enact legislation that limits how you talk about pain and suffering. There's something called the Anchors Away Act, which is meaning you can't suggest a dollar figure to a jury as to what the value of someone's pain and suffering is. I've always, in my own personal practice, I've rarely suggested dollar figures to juries. I've usually, in my biggest verdicts, I've always just, said, think about this, think about that, and the loss here is enormous, and no amount of money that you could award will ever bring back Mr. Smith or Mrs. Jones or whoever the victim is. But there is a perception that, if the plaintiff lawyer suggests to the jury, well, $30 million is an appropriate amount of compensation, there's something wrong with that. There's some legislative attempts to do away with that. There are actually some states that you can't mention a dollar figure to juries. I mean, Pennsylvania used to be, or still is, I think, one of them. And there have been, verdicts in Pennsylvania that are just as large as you see anywhere else. So I'm not sure if this is just a solution in search of a problem, or if there is, some social science behind it. But I would argue that my clients and I as a lawyer should be able to talk about their damages in a way, and if that includes suggesting a dollar figure to the jury, there's nothing wrong with that. Mark talked about a couple of areas where the plaintiffs, the perceived plaintiff's bar was changing the law, and I guess the classic one is wrongful death damages. How many of you remember the old tort law joke in law school? If you run over somebody with your car, the best thing to do is to back up and make sure they're dead. I mean, has anybody ever heard that? I mean, from my perspective, a lot of states, up until fairly recently, had a rule that the pain and suffering of the plaintiff dies with him or her. And, why that is never made any sense to me. I mean, the pain and suffering is a real damage inflicted on someone. Why is it that just because the defendant killed them as opposed to horribly injured them, that they can't recover, the pain and suffering that they suffered before they died? Or why is it that the category of people that can sue in wrongful death cases is much more, limited, than just in the plaintiff bringing his case or her case? Why is it that in Florida, a parent can't recover for the death of an adult child, no matter what the circumstances are? Why is it in some states that adult children can't recover for the death of their parents? So there have been reforms around that. I think, California fairly recently passed a law that revived or created the right for pain and suffering to survive the death of the plaintiff. And so, I would argue that's sort of fundamental fairness and not necessarily a bad thing. Statute of limitations reform, I think a lot of that started from the great abuses by, institutional organizations where trusted members of society, whether they be, Boy Scout leaders or priests or whatever, were abusing, minor children. I think there was an outrage there that says, wait a minute, even though this happened a long time ago, there should be a right of action, even though it would ordinarily be barred by the statute of limitations. In asbestos, for example, in New York in the 70s, I think it was law was changed in the 80s, where the first asbestos cases there were barred by the statute of limitations because the injury occurred when the person breathed in the asbestos dust and it started to damage their lungs, but they didn't know they didn't get cancer until 30 years later. And so there was a change in the statute of limitations to reflect that in the 80s. And so I think this is sort of the same thing that's going on in other contexts, to recognize that just because something happened a long time ago, it may have consequences now, and you shouldn't automatically bar that by the statute of limitations. My final comment is that, yes, there is a change, I think, in the nature of, the dynamic between Republicans and Democrats nationally. I think people see that, and it is affecting the type of issues that Mark deals with and I deal with. I mean, there have been and always have been Republican trial lawyers. I mean, if you think about it, the classic small government, market-based solution to a problem is to not have a federal regulation on toaster safety. It's to have, if 12 people off the street think that the company that made the toaster did something wrong, they can hold the toaster company responsible. And so what is new is that people that used to be Democrats are now Republicans, and a lot of those people would be very good jurors for my clients in many different types of tort cases. So that has sort of, I think, changed the game. And in terms of the money being spent on attempts to influence state legislatures, I would still argue that corporate America spends a lot more money or has a lot more money to spend on that than trial lawyers do. If you added up all the plaintiffs' bar in the entire country together, whether that be a Fortune 500 company or not, I don't know. But there are thousands of plaintiff lawyers in thousands of different firms. But something like the Chamber of Commerce or the American Tort Reform Association has some of the biggest corporations in the world that are always paying attention to its interest. And I think there's this thinking that the plaintiff's bar has a collective strategy. It's much more like herding a bunch of cats than having a collective strategy. So with that, that's my presentation, and I think it's time for the moderator to have some questions.
Oh, yes. Well, that was
Thank
just
you.
fascinating. Now, my first question is, does the AAJ, American Association of Justice, have a lobbying arm? Do they actually go lobby Congress and or state legislators?
On Congress, yes. On the state legislature, every state bar has a state-level AAJ that has a greater or lesser influence. But for pretty much all my career, it's mostly been playing defense as opposed to being on offense to change things. Only recently has there been some interest in changing things like the availability of different types of damages in wrongful death cases.
Well, I have to admit that I've learned so much just listening to the both of you, and coming from Hawaii, I didn't realize that there were so many different limits and caps on damages and punitive damages and the kinds of people that could sue for wrongful death. We don't have those kinds of limitations in Hawaii. So in any event, Mark, what about responding to anything that Nate has said?
Well, he did a great job. I think, one of the other issues that maybe goes to explain some of the things that Nate pointed out that on the defense side that we are looking at or focused on are, looking at things like plaintiff anchoring, asking the jury for $30 million or $1 million a year in pain and suffering, and then seeing the juries turn around and give them that exact amount. Or comparisons to what it cost to train an Air Force fighter pilot. $40 million the government will spend on training a fighter pilot. And then they make the argument that obviously, if the government thinks that somebody's life is worth $40 million, then if somebody dies because of the fault of another, then you ought to give them $40 million. Things like that. I saw there was a really good opinion from the Texas Supreme Court recently that tried to rein that in and say, hey, it's got to have something to do with this case. You can't just bring in, outside figures. But I think what some of these are maybe a reaction to, and you may see more interest on the defense side in dealing with what we call nuclear verdicts. I think which is a very complicated situation in terms of what is leading to nuclear verdicts. We know from data, and the U.S. Chamber put out a survey that my colleague Carrie Silverman did last year, that if you look at what's happening with jury verdicts, it is absolutely a fact that nuclear verdicts, being verdicts of $10 million or more, are becoming not only more severe, but more frequent. There were over 1,400 awards in the last decade of more than $10 million. I mean, that's astronomical to me. I know I'm getting old, but when I first started, if you had a tort case that was $1 million, that was a big deal. I mean, $1 million when I started would have been like somebody that was a quadriplegic or had burns over most of their body. Now that's a slip and fall case. I'm looking at, in the last week, if you saw me on my phone, it's because I was trying to look up, in the last week and a half, for example, in the Roundup litigation. This is a product that's been approved by regulators all over the world, has been studied by more than 50 years. It's not asbestos. Every agency in the world that has looked at this said it does not cause cancer. And there were 2 single plaintiff verdicts in the last week and a half. 2 plaintiffs, one in San Diego and one in Philadelphia, and the awards were over $500 million. $175 million to one plaintiff in Philly, $330 million or so to a single plaintiff in Philadelphia. The same week, another Philadelphia jury just awarded $1 billion to somebody that was paralyzed in a Mitsubishi vehicle rollover case. This is not sustainable. I mean, it just is not sustainable to see these awards that are coming out. And it's a combination of all the things I think that we've talked about, the changing demographics in the jury, this populist attitude that we say is complicating things for business in state legislatures. It's making it really difficult to try cases before juries as well. It has to deal with changes going on in society. The plaintiff's bar has gotten much better at how they litigate the cases. They've pivoted away from making the case about sympathy for the plaintiff and making it about generating anger towards the defendant. They've changed their tactics, whether you call it now reptile theory or using plaintiff anchoring. Now, I've heard some plaintiffs say, in the past, we just didn't ask for enough. When we asked for $1 million and we got it, then we asked for $5 million and we got it. Now we asked for $30 million and we got it. We get it. Maybe before they just weren't asking for enough. But anyway, that's something that is happening. It's not sustainable for corporate America. It's going to impact all of us in terms of the cost. You think inflation is going up? Wait till companies have to start baking these awards into the price of everything they sell. So it is something we have to deal with as a society. I think it's something that you all have to deal with as judges, because there is going to be a certain amount of social inflation, meaning awards that go up as inflation and prices in the rest of society go up. We get all of that. But when you have tort awards that are going up at a dramatically different pace of inflation than everything else going on, it's going to result in some sort of correction. It's going to result in more legal reform or loss of products in society or higher costs in society, and it's going to make it very hard to settle cases. How do you settle a case? If the historic value on a case was $7 million and now plaintiffs can get $30 million, is a plaintiff going to settle that anymore? Let's say it's an asbestos case in New York City. If the historical value is 7 million and you think you can get 30, are you going to settle that case? It's going to slow down and jam up the court system, I think, too. And that's my one legal reform plea to you, is that you all have an important, a critical job, I think, to try to hold the line on historical values of cases. Because if the appellate courts buy into this idea that $30 million is a normal award for people, it is not going to be sustainable for our society, and it is going to jam up the courts. And so there I go with my last pitch.
Nate, your response to this?
Well, my response is using the idea that the reptile is something new. Ron Motley, my former senior partner, was winning jury verdicts in the 70s and 80s by getting the plaintiffs mad at the corporate defendants not sympathizing with the plaintiff. It's been probably Abraham Lincoln, when he was trying cases, used that strategy. And asking for money, I've used it's not the training of the fighter jet, it's the cost of a fighter jet. What the argument is, we value life very highly in this country, and we are willing to, if a fighter plane is worth $30 million and it's about to crash, we want the pilot to eject, not to stay in to the last minute. Maybe that's an anchoring strategy, maybe that's not. In the context of an asbestos case, my client breathes in 10 million asbestos fibers in a day, or whatever. I think that the nuclear verdicts are a reflection of a good deal of anger at corporate America, and a good deal of things that have, inflation has taken off recently in areas that count under CPI. But in terms of healthcare costs, in terms of housing costs, and in terms of education costs, which are the three biggest costs that people face in their life, inflation's been rampant for years. So it doesn't surprise me that there have been, jury verdicts that have gone up dramatically, particularly post-pandemic. And I would argue for every, story you hear about a nuclear verdict, what you don't hear is, well, what happened to that verdict? Was it remitted? Was it reduced on appeal? Was it kept on appeal? Mark, you said there were 1,400 verdicts of greater than $10 million in the past year? Or how many years? 10 years? Yeah. That doesn't strike me. Every case is different. Every fact is different. I mean, if anyone's looked at a life care plan for a quadriplegic, it can easily run for up to $30 or $40 million to take care of them in a way that, would be a gold standard of care. And why should someone who happens to be poor get less care than someone who happens to be rich if they're rendered a quadriplegic by the fault of someone else?
Are you trying more asbestos cases, or are you settling them?
We settle cases whenever we get reasonable values. I mean, the vast majority of asbestos cases resolve, and
just your idea of reasonableness may have
no, yes, the value of an asbestos case has gone up, but nobody is going to. At the end of the day, what you have to keep in mind, and it's something where you have a repeat litigation like asbestos, or a repeat litigation like cigarettes. Not that there's a whole lot of that anymore, but in any kind of mass tort, the people that Mark represents in the insurance industry are repeat players. I may be a repeat player, but my client, it's his or her only shot at justice, and they're going to be much more risk averse and much more inclined to take a settlement offer on the table than to go to the jury verdict. I mean, I've had clients tell me, even though I said, you could get an 8-figure verdict here, they would say, take the $200,000 on the table, because I know that's going to pay off my house and pay for my kids' education and pay for the unreimbursed medical bills. That's a very different, analysis for a single person versus somebody who's a repeat player. So that's my response to Mark on nuclear verdicts.
Very interesting. So, I'd like to open it up to questions. Does anybody have any questions or comments in terms of legislative developments in their states, or else questions directed to any of either of our speakers and things that they have said? And thank you. I see one person coming up, and I ask that you go ahead and come up to the microphones, perhaps identify yourself and your court, and then go ahead and ask your question. Thank you.
Good morning. My name's Sean O'Donnell. I'm a trial judge from Washington State. Really appreciate your comments on jurors and the juror experience. It's going to be slightly long of a lead up. So everything you said is spot on. Jurors can't afford, or a lot of jurors can't afford to do jury service, and most states look at the cost of raising it so low-income jurors could do it as being prohibitive. I mean, it'll be tens of millions of dollars if you had minimum wage for jurors to serve. During COVID, we transformed the jury process in King County. We let all of our jurors, we do jury selection entirely by Zoom. And I'm wondering if your associations have discussed supporting something like this in other states. And the reason I ask it is, we have a 20% response rate to juror summons. In Zoom, instead of 2 days in the jury room, jurors get an hour and a half. They can be at home, they can be at work, they can be at school, and they don't have to pay for parking and lunch and all those other things. We've never had an instance of juror misconduct from selection over Zoom. So I'm wondering if that's something your associations have discussed and would support, because as we look at this new generation, everybody's on the cell phone, and convenience for jurors is huge consideration. So anyways, cue that up for you both.
I don't know if the American Association of Justice has a position on that, and I think trial lawyers generally like to be in the room with the people that they're asking substantive questions of. However, if technology and things like Zoom can greatly expedite the jury qualification process, meaning things like hardships and whether they have a medical issue or whether they have some kind of obvious issue that they can't serve on the jury, then from my personal perspective, I have no I would encourage that. I mean, in Washington, D.C., they have a system called one day or one trial, meaning you only have to you serve for 1 day a year as a juror. If you get picked for a trial, you sit for that trial. But if you're not picked, you're done. And that was a way to expedite the jury process. I think doing things like basic qualifications and whether there's a hardship, by Zoom or some other way, is a great idea. I mean, I much prefer for jury selection to take a day or 2 days than for it to take a week. And I think a lot of jury selection does involve questions about hardships and things that can be done, quite, expeditiously by Zoom or otherwise. So while the AAJ doesn't have a position on that, I'm a firm believer in using technology to expedite things and make it easier for people to sit on juries.
Yeah, I'll share an interesting experience, and I don't think that the defense bar or civil justice groups have a position on that either. I think if you interview most defense lawyers, they would have the same viewpoint that Nate has, is they want to see the juries when they're doing voir dire, they want to see their faces. When they see the witnesses, they want to see what they're doing and things like that. But I'll tell you, it's kind of an interesting, at the beginning of COVID, there was an initial push for some courts to do Zoom trials. And folks on the insurance side thought, this is going to be horrible. We have to oppose, and I think I did an op-ed at one point that said, this is terrible, we can't do this, we have to have trials. The first cases that actually went off as jury trials on Zoom in the Bay Area resulted in, I think, a defense verdict and a very, very low plaintiff verdict in mesothelioma cases in a very difficult jurisdiction. And in talking to the defense lawyers afterwards, they said it turned out that they thought the dynamic played to the defense because the jury didn't have to sit there for a month every day and come in and see somebody that was dying of mesothelioma. There is a desensitization that when we see something on TV, we see these horrific images in Gaza or Israel on TV, and they are horrific. If we were actually there, we'd have PTSD for the rest of our lives, right? there is a distancing that occurs by watching things on TV, and I think that same kind of thing has translated on the limited evidence that we've seen in the jury trial experience as well. That the juries don't connect as much when they don't see the plaintiff, and also they may see him testify and then they're off the screen. You know, when you're in a live trial, you can maybe hear an expert testifying, but you can still see the plaintiff. If you're on a Zoom trial, you're just getting the expert. So I don't think there is going to be consensus that says we ought to have Zoom trials, because I think plaintiffs have reason to be suspicious of that based on the limited data points that we've seen, and I think just both plaintiff and defense bars want to see, they want to be there and they want to see the people and try to read body language. So I don't think we'll go there for trials, but, you know, for
Yeah,
motions
I'm
and
opposed to
things like
Zoom
that.
trials
Yeah,
where
yeah.
for
Motions,
jury trials.
maybe it makes sense. I
but-
mean, it doesn't make sense to make somebody fly to, you know, the middle of nowhere and for a 15-minute motions hearing. I mean, that's
Right.
just a waste
We've
of
got-
money.
We've got a lot of people
Yeah.
to ask questions, so please go ahead.
Judge Albertson, I'm out of Southern Nevada in district court, and I was wondering, this is more for Mr. Finch, I guess. Are there numbers on the other side of that? Because I actually see, and I saw even in my practice before I became a judge, a lot of attorneys asking for really large verdicts and not getting really large verdicts. And is there any thought to maybe the numbers are a little skewed right now just because information is shared so much more
Well,
frequently
for,
and so much more easily currently?
thanks for that question. For sure, you hear about the home run gigantic verdicts. You don't hear about the 10 defense verdicts, or you don't hear about the plaintiff lawyer asks for $30 million and gets $1 million, or you don't hear about the cases that never get to a jury that should get to a jury, or you don't hear about the case that it might have been a nuclear verdict, but it's remitted, you know, by the trial court judge to $10 million, and then it's reduced on appeal to $3 million. So in terms of nationwide statistics for recovery of what people get, I don't think there's any good source of data. But I very much agree with the premise of your question that people hear about the really large verdicts, but they don't, you know, in terms of the size of them. But I think if you did an empirical study, you would find there are far more low verdicts or defense verdicts or verdicts that are moderate in size. I still think, I mean, if Mark is right and there were 1,400 verdicts in excess of $10 million over the last 10 years, that strikes me as not a whole lot of large verdicts when you compare to how many defense verdicts were there over the same period of time, or how many verdicts of less than $1 million. I mean, most trial lawyers go their whole career without ever having a 7-figure verdict, and I've been fortunate enough to have a couple of 8-figure verdicts, and I don't know if I want to say this in front of this audience, but I actually did get a 7-figure verdict in a slip and fall case, but that had nothing to do with the pain and suffering. It had everything to do with the economic damages. So you hear about the outlier verdicts, but you don't hear about the vast majority of cases that don't end up in nuclear verdicts.
Thank you.
And
Thank
there's
you.
no source for it, like there's, just like I said, just out of fairness, trying to look at both sides of this.
Yeah, I think, I mean, you know, there is data I've seen. The problem is in a lot of the states, it's not data. The state courts don't keep that. I think in Med-Mal, you know, it's been pretty well documented. I think that it's a 50-50. The defense might win slightly more than they lose in Med-Mal. I think in asbestos cases last year, at some of these conferences they put up, it was maybe 50% plaintiff and defense verdicts. It's pivoted maybe a little bit more to the plaintiff side. But it's not all doom and gloom in the roundup trials. I mean, this is maybe one of the problems that the defense side has about the just complete randomness of our civil justice system. You know, I talked about those 2 Behr verdicts in last week that were $500 million. The last 9 verdicts in a row have been in Behr's favor. So how do you explain that? It's the exact same product, exact same injury. All of these people are alleging. 9 people get nothing because the jury sides with the defendant, and then 2 people, $500 million. I mean, this is a problem, I think, and I've written about this in our justice system, where there is just complete and utter unpredictability from not only one jurisdiction, but from one case to the next. I think that hurts the perceptions of our justice system, that people do see it as a lottery. And I do think that it is incumbent on all of you to try to find rational ways to even some of this out. because I don't think it's good for society to have just complete randomness occurring in our courts. And a lot of it has to do probably with admissibility of expert testimony and which jurisdictions are more permissive on that than others.
Okay, thank you. I'd like to try to make sure we have time for all of the questions. Please proceed.
Yes, my name, my name is Mark Spicer. I'm a circuit court judge in Fort Lauderdale. I just wanted to direct my comments to what Mark was saying about how the premiums have gone haywire with respect to homeowners. But as high as the insurance premiums have been going, the amount of litigation emanating from what we call water damage cases in Florida, if you have a mortgage, it's not required by statute, but every mortgage company requires you to have hurricane insurance, which is homeowners insurance. And the bottom line is the litigation has multiplied to the point that the number of water damage cases are overwhelming. It's the bane of every single judge's existence to have to try a water damage case because they never settle. They never settle. They make the homeowner go through so many hoops, it's beyond the wildest imagination. So I would say at least 30% of the trials that we have in Florida are water damage cases. Secondly, with respect to juries, it's a major problem. Like in Broward County, where I am, Monday, Tuesdays, and Wednesdays, we summon 1,000 jurors every day. We have about 350, 375 that show up. It's ridiculous. And the clerk is the one who's responsible for doing this, but they don't have the authority to take any action, and no action's ever taken against the jurors who don't show up. We used to get our jurors from the list of people that were registered to vote. We found that a lot of people would deregister to vote or not even register to vote in the first instance to avoid being called for jury duty. So now we use the people that have valid Florida driver's licenses that live in Broward County. But the problem is we have no teeth. We don't get the diversity that we thought that we would get by using people that have, as jurors, people have driver's licenses. So it's a sad commentary, and the problem is, the problem rests with the legislature with respect to empowering the clerk of the courts to take action to bring in jurors that don't show up.
Thank you. Thank you for those comments.
Hi, I'm Justice Catherine Levine from Kings County, New York. I'd like the panel to comment on the discrepancy between obtaining emotional distress from wrongful death, which is quite limited in New York, versus medical malpractice. Are there any states which permit family members to get the emotional distress and suffering from a wrongful death of a beloved one? Because it's very circumscribed in New York. If you could give me a global sense. Thank you.
I can only from states where I've tried cases. Like in Virginia, for example, you can't recover for pain and suffering of the person that died, but the widow can get emotional distress damages that can be quite substantial. The same thing in other states I've tried cases. In Florida, for example, you can't get pre-death pain and suffering either, but you can get, or maybe it's not Florida. It's another case another place I've tried cases. But in South Carolina, for example, pain and suffering of the decedent survives the death of the victim. So I think it's very much a state-by-state issue, and there are states where it's not as nearly as limited as it is in New York. And my view is a life is a life, and just the fact that someone dies shouldn't devalue the value
Right.
of their claim.
All right, thank you.
All right. Next question.
Hi, I'm Ann-Lee Moe, and I'm from Tampa, Florida. I serve on the circuit bench here. So I wanted to ask, I know we're going to talk more about third-party litigation funding, but in Florida, we have something that's sort of unique in the sense of different mechanisms to allow litigation to be pursued. We have something called letters of protection. And I wondered, number one, how unique is that to Florida? And by letters of protection, I'll define it as a situation where a doctor treats a patient, holds the bills, and basically will say something akin to, maybe I'd get $1,000 for this procedure if I use Medicaid or health insurance, but I'm going to put on the books that it's $10,000. And it will be done with the expectation that we're going to find out what that value of the procedure was once we have either a verdict or a settlement. And then they go back and negotiate it down in essence, it becomes a way for a doctor to kind of participate in the outcome of the litigation while also inflating the bill for the purpose of making sure that the recovery is as high as possible. How prevalent is that outside of Florida? And in any other jurisdiction outside of Florida where that mechanism is used, are there different ways of identifying, another, and I know we have a statute in Florida that deals with this now, but any other forums that deal with how to address that particular scenario?
Yeah, I think, good question. Welcome to Virginia. I think.
Welcome to Florida.
Yeah, thanks. I think some of this is, it's interesting. The tort war is sort of a chess game. So one issue that the defense bar has fought over the last decade or so is something that on our side we call phantom damages. That's when the plaintiff lawyer is allowed to board the undiscounted value of the plaintiff, the billed value of the medical bill, not the amount the plaintiff actually paid. I'm going to get to your question because one is connected. So in many states, I've got little kids, so there's always somebody that's going to is sick for something, right? So when you get your medical bill, it'll say on there, the doctor visit, $350. And then it'll have under it like group discount, and then the amount, the negotiated rate, and then minus any amount that the doctor will write off. And then at the end it says the amount you pay, and it's like $40, right? It's 10% of what the actual bill is. In many states, the jury is told your medical expenses are $400, not the $40 that you actually paid. So what's happened on the legislative front is, on the legal reform side, we've countered that by saying the jury's only told the amount that they pay, not the inflated amount. We call it phantom damages because it's an amount that nobody actually pays. It's been written off. In reaction to that, the plaintiff's bar is moving to letters of protection. So it's, let's find a doctor who's willing to work in cahoots with a plaintiff's attorney to essentially do a medical procedure on a contingency basis. Because then what they'll do is they'll say, let's say a surgery, Medicare pays $1,100 for a surgery, this doctor will charge $10,000. And specifically tell the client, we will not take insurance. And you don't have to pay the doctor anything unless there's a recovery in your lawsuit. And if there's a recovery, then the doctor gets $10,000 for that procedure. That's being done in response to these Phantom Damages Act, because the amount of the damages then is, right, $10,000.
But it's more than that, because often in the life care plan, the same procedure is projected to be necessary, every month for the rest of their life.
Right. So I don't think this comes up in states that still allow plaintiffs to board the full uninflated amount, because you don't need to do this workaround, I'll call it. But in states that have dealt with collateral source reform to try to tell the juries the real amount plaintiffs are out of pocket, then this letters of protection is the way plaintiffs are trying to work around it. And Florida dealt with it this year by saying it's not reimbursable beyond what insurers would have ordinarily paid for that procedure.
Okay, I noticed that there's a website that talks about the collateral source rule in each state, and it sounds like Florida doesn't have a collateral source rule prohibition. So in any event, last question?
Calvin Hawkins, I'm a jurist up in Northwest Indiana. You were talking about the difficulties of getting panels for trials. I've never had that problem, and it's not unique to me, at least in our area. The problem is getting jury trials, because now with alternate dispute resolution, we have mediation. And in our area, we have a local rule, you can't get a jury trial setting unless you've gone through mediation. Now, I've publicly gone on record. I know there are 2 jurists here from my state. I don't adhere to that rule. I'm not anti-mediation, but I don't think it should be another hoop that parties should go through to prevent a jury trial.
I agree with you.
And mediation should work when parties are are willing to sit down and see if they can settle the case. The other thing, and I'm probably more statements than a question, one of the things that we do what we do up in our area is that we have seminars, and we use jurors. It's called Jurors as Judges. And these are people that have sat on jury trials, and they talk about their experiences, the good, the bad, the ugly. I have never known any of our judges in Northwest Indiana having problems with jurors coming to court pursuant to a summons for notice from the clerk's office to be a part of veneer. So that's really not an issue. The issue to me and us are these mechanical procedures to prevent jury trials.
Thank you.
And I
Thank
read
you.
not just civil jury trials, criminal jury trials. There's been a diminishment of jury trials across this country.
Thank you for those comments. I'm sure many of us share some of those thoughts and sentiments. Thank you so much, everyone, for your attention. I'd like to thank the panelists, and we will break on time. Thank you.
Thank you.
We have another 15-minute break. Please be back here at 11 o'clock.